precoce, așa după cum știți majoritatea dintre dumneavoastră, și vreau să vă spun bun găsit și bun venit pe pagina mea de Facebook în această zi, Joia Mare, cum se spune în mod tradițional în România. Vă spun tuturor încă dinainte, Hristos a înviat, o formulă tradițională, dar și adevărată. Și din nou vă mulțumesc pentru că ați ales să petreceți aproximativ o oră din timpul dumneavoastră împreună cu mine în seara aceasta. În seara aceasta voi face ceva deosebit. Niciodată până acum nu am făcut un interviu în limba engleză sau într-o limbă străină pe pagina mea de Facebook, însă voi face astăzi din mai multe motive. Îmi dau seama că poate foarte mulți dintre dumneavoastră, cei care mă urmăriți în aceste minute, nu cunoașteți, nu înțelegeți limba engleză, respect lucrul acesta, dar vreau să înțelegeți că ceea ce fac în seara aceasta și poate chiar în viitor nu o fac din snobism sau dintr-un motiv de aroganță sau din alte motive nepotrivite. O fac datorită faptului că evenimentele care se petrec în jurul nostru, atât în România cât și la nivel european și la nivel global, sunt atât de importante, atât de relevante pentru România și pentru valori, pentru mersul societății, atât în România cât și la nivel european și global, încât m-am gândit că este bine ca pe lângă mine să am din când în când alte persoane care să discute subiectele acestea, care sunt experți în domeniu, poate chiar mai mult în expertiză, mai multe cunoștințe de expertiză decât mine în aceste domenii. Și din nefericire anumite persoane le găsim care pot discuta subiectele acestea doar în afara României și nu vorbesc limba română. Deci vă mulțumesc anticipat pentru înțelegerea dumneavoastră. Îmi dau seama de asemenea că mulți dintre dumneavoastră știți limba engleză, puteți să scrieți cursiv, puteți să înțelegeți foarte bine limba engleză. Deci vă mulțumesc că ați intrat cu mine astăzi pe pagina mea de Facebook pentru acest interviu și vă rog chiar foarte mult, cei care cunoașteți limba engleză, chiar limba română, vă rog să faceți comentarii pe pagina mea de Facebook și dacă aveți întrebări pentru oaspetele meu din seara aceasta, va fi plăcerea mea și onoarea mea să citesc mesajele dumneavoastră, întrebările dumneavoastră pentru colegul meu și el, sunt sigur, va răspunde întrebărilor dumneavoastră în măsura în care sunt sigur ele vor fi de bun simț. Deci, pe scurt, în seara aceasta voi avea o discuție cu un domn extraordinar. Numele dânsului este Gregor Pupnic. Dânsul este un avocat internațional care își are reședința în Strasbourg, în Franța. Este un avocat de prestigiu mondial, iubește valorile, iubește România, iubește creștinismul. De fapt, dânsul este un creștin autentic. Și în seara aceasta vom discuta câteva subiecte privind aspectele europene și privind evoluția valorilor la nivel european, din perspectiva Parlamentului European, din perspectiva mai ales a Curții Europene a Drepturilor Omului. Deci, în câteva momente o să încep să discut subiectele mele cu domnul Pupnic în limba engleză, dar din când în când o să fac și o mică pauză pentru a face un mic rezumat a comentariilor dânsului. Deci încep conversația mea cu domnul Pupnic. Gregor, good evening to you.
Good evening. Good evening.
It's really a pleasure to have you with me today. And as you spoke for about 5 minutes earlier this evening, I am very, very pleased that you have honored me, you have honored my invitation, and you have agreed to do this interview with me on my Facebook page. I told the people in Romanian that you are an extraordinary man, and I'm not saying that I'm bragging on you, sort of, but I'm saying that because I have watched you for a number of years. I have watched what you are writing. I have watched what you have stated for a number of years. I have watched your many successes in the European Court of Human Rights with respect to civil rights, human rights cases, which defend the right to life of the unborn, traditional marriage, religious freedom, and so on and so forth. And so I told my colleagues in Romania, tonight we are going to have an extraordinary person having this dialogue with me on very important subjects which impact not only Europe, but also Christianity as a whole and also Europe. So again, I want to thank you very much for spending the next hour or so with us. And what I would like to do, Gregor, for the next couple of minutes is I would like to ask you to tell us a few things about yourself. All I know about you is indirectly from what I read. but I think it's appropriate for you to also let us know in a couple of minutes a few things about yourself, your education, your background, your family, and what makes you tick, what keeps you going with respect to values and your love for Christianity and Christian values. Go ahead, please.
So thank you very much, Peter, for this invitation. I'm very pleased to be with you. It is true that we have been knowing each other by email and indirectly for a number of years, and I also very much appreciate your work, what you're doing, and also your legal expertise. So just to introduce myself briefly, I am French. I live in Alsace. I am married. I have two children. I am a dedicated lawyer. I really have a kind of passion for law and justice. I am also, moreover, Catholic. I am a French Catholic, I would say. So I have a love for a passion for truth and justice. And this is what I would say helps me to work every day. This passion for truth and justice that is in large extent unified within both faith and reason. So faith and reason do not oppose each other. They are complementary and they serve each other. And so this is really my passion. To answer your question on my personal involvement and motivations. Otherwise, my profession, I am the director in Strasbourg of a non-governmental organization, which is named the European Center for Law and Justice. It is a non-governmental organization based in Strasbourg, founded in 1998, close by the European Court of Human Rights, and more generally the Council of Europe, which is in Strasbourg. So we mainly work with this institution, as well as with the United Nations, which is based in Geneva, which is not very far from Strasbourg. So we mainly work within those two institutions for the promotion in general of human rights, but more precisely on a good and proper interpretation of human rights, on protection of freedom of conscience, freedom of religion, as you said, as well as life, freedom of expressions, and so on. We defend a lot the Christian communities in Europe and also abroad. We have been working on many cases before the European Court of Human Rights in order to defend the Christian communities from the state. So those are some aspects of the work, but we also do some kind of advocacy or lobbying within the European Parliament on issues, for example, of abortion currently. Maybe we'll speak about it. So this is what we do. We are a small team. We are 4 people working here in Strasbourg. We have some interns. We have some external collaborators working, for pro bono. So we have a large team of collaborators as a total, but we are still a small organization here in Strasbourg. But we are all passionate by our work. So this is what we do. I've been here for 20 years, so I could follow many of the debates that have occurred during this time in Brussels, Strasbourg, and Geneva. We took part in many cases, many important cases, and also we witness the strong and deep political changes that are occurring within those institutions. We may be able to speak about it as well.
Okay. Well, I thank you very much for this wonderful presentation. You certainly are a person which fights in the trenches, as we say in the United States, for the cause of Christianity, honor, and all of the Christian values that are so dear to all of us. Let's go ahead and tackle some of the subjects that I would like to discuss with you tonight. And what I would like to do is, I would like to start out by focusing on the European Parliament. And let me make a brief preface to what I'm going to discuss with you with respect to the European Parliament. Approximately 3 or 4 months ago, I spotted in the European Parliament a draft of a possible resolution or report, which sort of gave me pause and some concern. And that is the MATIC report, or MATIC report. I do not know exactly how you pronounce that precisely in Europe, but I read this as the MATIC, MATIC report. And frankly, it gave me a lot of concern because in reading the document, it seems to me that it seeks to promote in Europe the notion that there are two important aspects of European law, and I might be wrong about this, but I disagree with the MATIC report. But the report clearly indicates that European law, and that's a mystery to me as to what exactly that is. European law recognizes the existence of what the report calls reproductive rights, number one, and number two, sexual rights. Obviously, when you talk about reproductive rights, inevitably you end up talking about abortion. And so I'm going to ask you a question about abortion and whether or not this actually is a right under European law, under the jurisprudence of the European Court of Human Rights. And also I would like to ask you questions about the so-called sexual rights, which the MATIC report seems to promote in the European Parliament, if obviously this report is adopted. And then let us know, whether or not, for instance, there is a right in the in European law to, for instance, same-sex marriage. So it is a report which is of great concern, not to me, but to a lot of people. A lot of people have actually approached me about this report, and I think I posted maybe 2 or 3 comments on my Facebook page about the MATIC report. Again, it concerns me, and I would like for you to, again, tell the public in Romania what your feelings, sentiments are about, your opinions, impressions are about this report.
Okay, so yes, it is. So we call it the MATIC report. It is one draft report that has been introduced within the European Parliament by a number of members of the European Parliament, and its aim is, of course, to promote the idea that there would be a kind of fundamental right to abortion and a duty on member states to allow abortion. As you may know, Poland Constitutional Court has recently ruled that there should not be any abortion, even in some cases, extreme cases that was still allowed it previously. And so this provoked a strong reaction within the European Parliament. And among those reactions, this draft resolution that is very problematic considering its content. However, we may say first that the issue of abortion is out of the competence of the European Union. It has been made very clear several times, including recently last month by the European Commission, that abortion is out of the competence of the European Union. So clearly, this draft resolution, as far as it deals with abortion, not only has is not compulsory on member states because it is only a resolution and not a law, but also it is ultra vires. It exceeds the competence of the European Union. So we may very much say that this text is a kind of advocacy, promotion, ideological initiative from a group of radical leftists from the parliament to promote abortion, using the parliament as a political tool to promote abortion, whereas it has no competency to do so. In 2013, the previous similar initiative was introduced by Mrs. Estrela, and you may remember that it failed before the European Parliament at the end because the members of the parliament reaffirmed the fact that there is no such competence from the European Union on abortion. It only belongs to member states. Member states are free to decide on this issue. It is one of the clearly a consequence of the treaties. We may also say that this resolution is not loyal. I mean, it's quite of hypocrite because it used a large number of sources, of references in support of the idea of a right to abortion. But when you look to all those references, it clearly appears that they have no direct link and they cannot support at all the assertion, the affirmation of a right to abortion. So this is what we can say. It is a political abuse from a group of members of the parliament. But of course, it can have a strong political effect on the states, but it may also encourage the European Commission to support programs abroad, outside of Europe, within the field of the financial help for development, especially in Africa, to support activities of family planning, because we may have to know that there is another problem. Although abortion is not a competence of the EU, but the EU finances, directly or indirectly, family planning, including abortion, in developing countries, through the money that we give to those countries for the development. There is currently a negotiation between the European Union and the African states on the new program of help of development, and the EU, one of the conditions set by the EU in order to receive those grants is to implement programs of sexual rights, family planning, and so on. So clearly, we can see that it is not so clear. The attitude of the European Union is not so clear on this matter. More generally, we can also say that seen from the European Court of Human Rights as well, there is no right to abortion. This is something that is very clear. The court always refused to create or declare such right. It also let the issue for the member states to decide depending on the circumstances. So this is what we can say. But yes, there is a big political debate, fight in Europe on the issue of abortion. This debate is becoming more and more violent ad hominem. We face personal attacks, direct, strong personal attacks in the media from the promoters of abortion. They don't anymore really fight our arguments, but they try directly to fight our organizations, to discredit. So we are now in a new situation because in order to get this resolution voted, the promoters of abortion have initiated in the same time, simultaneously, a campaign in order to discredit the pro-life organizations in Europe. So there is a full strategy that is implemented currently. And you will see next month in May, I guess this campaign will increase. They will publish, documents telling, that we would be dangerous organizations because we promote life. We are against abortion, so we would be organizations opposed to European values, dangerous Christian organizations, with financed, by foreign organizations, American organizations, and so on. So this is what will happen next month, and some commissions of the European Parliament are even considering introducing a report on us to explain how much dangerous are the Christian conservative organizations in Europe. So this is what the current situation that is not so peaceful.
Yeah, it certainly is a document which makes me cringe to some extent, because indeed, if the European Parliament adopts this document, it's going to have tremendous impact intellectually, ideologically, and pressure on the member states. And I did like what you actually pointed out, because it's so accurate. You mentioned, first of all, that this report more or less has one enemy, and that's Poland, which, of course, we know earlier in the year declared that there is no right. I apologize. The Constitutional Court of Poland made it very plain and clear there is no right to abortion under Polish law, not even for the purpose of euthanizing an unborn a fetus that suffers from malformations and so on and so forth. What I also liked very much what you said was that the abortion, and I want everybody to understand, abortion is not a European competence, like Gregor said. In other words, Europe, the European Union as a whole, does not have the right to tell member states that they've got to accept abortion, they've got to legalize abortion internally, because, again, abortion is a matter of domestic jurisdiction, domestic authority, and so on and so forth. And I also like what you said, Gregor, because indeed, in looking at the Matic report in the last couple of weeks, I realized that a similar attempt was made about 6-7 years ago, and I think you mentioned the Estrella report, which again attempted to bring about, by way of European resolution, the recognition in the European space, in the European Union, of a right to abortion, and that attempt then was defeated. So hopefully it's going to be defeated again. Still, a second question that I would like to discuss with you, and I would like for you to clarify for the public as well, is this concept of sexual rights, which the Matic report promotes. And again, I'm going to be direct with you, and I've been sort of shocked by what I have read in the report. But again, can you tell the public, is there a right under European law, or I should say under the jurisprudence of the European Court of Human Rights, a right to same-sex marriage, or a right to civil unions between persons of the same sex or the opposite sex? It's a hot topic in Romania right now. Romania forbids, interdicts same-sex marriage since 2009. And so I think that the public would like to know a few details about this area, this aspect.
So it is the same answer than regarding abortion. Clearly, it is not an issue, not a competence for the European Union. So the EU has nothing to say, in fact, on those issues. So it's also an abuse from the European Parliament to take a stance on those matters and to tell to the states what they should do. The only rule that applies both in the European Union and in the European Court of Human Rights is the principle of non-discrimination, including for the matters of sexuality. And so it is only if there is a kind of discrimination decided by the parliament or by a judge that may have an impact on the legislation of marriage. So this is today the situation. The European Court of Human Rights has never said, has clearly said, that the European Convention of Human Rights guarantees the right to marry, I say in Article 12, I quote in Article 12, to men and women. So clearly, the European Convention of Human Rights only guarantees the right to marriage to men and women, and this is clear. And so the court also said that it has no power to change the meaning, of this article. However, the court, in the meantime, through its case law, declared that member states, based on the right to privacy, protection of private life, member states shall give some kind of legal status or legal accommodations to same-sex couples. This is what the court ruled in a case against Italy. So it does not concern marriage. So there is no obligation to legalize same-sex marriage, but there is a duty to provide some legal kind of framework in order to allow those people to organize their life on a legal point of view.
So we are talking about extending or affording same-sex couples some form of legal recognition other than marriage as such, correct?
This is the status of the law in Europe,
right,
from the European Court of Human Rights today.
And you mentioned a case against Italy, and I would like to talk about a little bit about the case against Italy, because then I'm going to ask you a follow-up question, which also involves Romania as well. I might be wrong about this, but my understanding is that the case that you mentioned against Italy, was that the Oliari case?
Mm-hmm. Yes.
Okay. Was that the case in which the European Court of Human Rights imposed on Italy the obligation to create some sort of a legal framework, yes, recognizing civil unions in Italy, right?
Yes, indeed. Providing
okay, go ahead, please.
Yes, providing a legal status or legal framework.
Okay. Now, this is a very touchy point for Romania as of right now in 2021. And let me tell you why. I'm going to make this comment for about a minute or so, and then I'm going to ask you a very important question, which has baffled me for many, many years with respect to the European Court of Human Rights. As of right now, there are, I think, 2 or 3 cases against Romania before the European Court of Human Rights. And these cases have been brought forth by same-sex couples who are asking the European Court of Human Rights to impose on Romania one of 2 obligations. Number one, either to impose on Romania the obligation to recognize or to create a legal framework for same-sex couples, sort of like in Italy, or in the alternative, number 2, for the European Court of Human Rights to recognize a right under the European Convention of Human Rights, a right to same-sex marriage. I'm not going to get into details about these cases. I'm not going to ask you what you might speculate about the outcome of these cases. But suppose that, let's say that the European Court of Human Rights will indeed issue a decision telling the Romanian government, 20+ million Romanians, from now on, you've got to adopt legislation in the next 2 or 3 years, which provides recognition for same-sex couples in the form of same-sex unions, civil partnerships. So the question that puzzles me, which I'm going to ask you, Gregor, is this. How is it possible for an international tribunal to compel a nation state in this age of democracy to legislate according to the wishes of the international tribunal? Obviously, what comes to mind, you're a lawyer, I'm a lawyer, the first thing that jumps into my face, into my mind when I discuss these issues with other people is separation of powers. Which means that courts cannot tell the government how to legislate, courts cannot tell the legislature how to legislate, what to put in the law, and so on and so forth. And so you're an intelligent, experienced man. I'd like to know what your opinion is in this regard. How can, again, briefly stated, an international tribunal impose an obligation on Italy and maybe Romania to legislate internally, to adopt internally legislation that would comply with a ruling by the European Court of Human Rights?
Okay, so your question is important if you consider the system of protection of human rights worldwide and as it developed in last decades. Normally, a court like the European Court of Human Rights or an institution that is established based on a treaty cannot change the meaning of the treaty. So normally, as United Nations, for example, a committee from the United Nations or the European Court of Human Rights their task is to make sure that the states respect their commitment, that the states respect their duties, the duties they undertook when ratifying the convention. So normally the court only controls the respect of the commitments. And normally a court, as well as a national judge, does not make the law. So it cannot change the content of the convention, or it cannot create new obligations on the states, because the state only committed to respect the treaty. And for example, the Convention of Human Rights is quite clear, and so the court has to apply it. So what happened? What happened is that the Court of Human Rights, but it is the same, in fact, as the United Nations, applied the theory from the United States Supreme Court that the Convention of Human Rights is not only a text, but it is a living instrument. They call it a living instrument. That means that it is a text which content can change through the time. So it changed everything, because the judges allow themselves to change the content of the convention through the time, saying that it is a living instrument, which means that you need to interpret it, of course, according to the new circumstances, but you may also change the meaning of its content in order to create and expand and develop its content and to develop new human rights. So all the ideology of human rights is very, we could say, progressist, as its purpose is to develop the content of human rights, to create, to find new rights, such as a so-called right to abortion or to euthanasia, that of course were never present while the Convention of Human Rights was drafted in 1949. Today, there is a discussion whether there is or not a right to euthanasia. I mean, if you put yourself right after the Second World War, it is obvious that no one wanted to establish such a kind of right that was implemented during the Second World War. But today, jurisdictions pretend that there is such a right. As well, today some jurisdictions, are considering refusing the right to conscientious objection to abortion, or which is once again clearly against the intent of the drafters of the Universal Declaration of Human Rights and the European Convention of Human Rights. So human rights is not only a matter of law, it is also, in a large extent, a matter of politics and ideology. Politics and ideology change all the time. They tend to promote new rights, promote new ideas, and so this is how we arrive to this situation. And it is clear that if a judge can decide on a law, can change the law of a state, even can force to change the constitution of a state, it is a real problem for the separation of powers between authorities within the state, because a judge would have the authority to go against the decision of the population. For example, on the matter of abortion, the European Court of Human Rights went against the decision of the Irish people that expressed itself through 3 referendums. However, the Court of Strasbourg said, okay, maybe there have been 3 referendums, but we consider that now it should change. So yes, there is a change. Human rights system is part of an important, strong, and large change within our political system, because we don't believe anymore, we don't trust anymore in democracy based on votes. So we want our society to be organized not only through the votes, but moreover through principles, values that are above the votes and above politics. And those principles, those values, of course, are human rights, but they are within the hands, they are under the control of international institutions that may interpret them sometimes against the general will of the population.
Yeah, fascinating explanation. If you'll give me about 2 minutes or so, I'd like to explain briefly in Romanian what you have taught us so far this evening. Dragilor, în limba română, am discutat cu Gregor subiectul raportului MATIC, despre care deja v-am scris de câteva ori pe pagina mea de Facebook și mă bucur să văd că Gregor și cu mine avem aceeași interpretare generală privind raportul MATIC. Trebuie, vă spunem din nou, ceea ce v-am spus eu personal de mai bine de 10 ani, nu există un drept la avort. Și așa cum spunea Gregor, Curtea Europeană a Drepturilor Omului nu a recunoscut un drept la avort în sistemul european. Curtea Europeană a Drepturilor Omului nu impune și nu a impus nici unei țări membre celor 47 de țări care formează Consiliul Europei să legifereze la nivel intern, să recunoască un drept la avort. De asemenea, privind căsătoriile între persoane de același sex, a menționat lui Gregor că în ultimii ani, ultimul 2 sau 3 ani, cam așa ceva, mai multe grupuri, cupluri de același sex din România au intentat un proces împotriva României la CEDO, solicitând fie uniuni civile, recunoașterea unui drept la uniuni civile, fie recunoașterea unui drept la căsătorii între persoane de același sex. Opinia lui Gregor este că este practic imposibil, cel puțin la ora actuală, pentru Curtea Europeană a Drepturilor Omului să impună României sau altor țări să legifereze la nivel intern căsătorii între persoane de același sex, în primul rând datorită faptului că în articolul 12 din Convenția Europeană a Drepturilor Omului se specifică foarte clar că căsătoria este uniunea dintre un bărbat și o femeie. Pe de altă parte, dânsul ne dădea exemplul Italiei de acum câțiva ani, când Curtea Europeană a Drepturilor Omului a forțat Italia să legifereze, să creeze un cadru legal pentru recunoașterea unor forme de conviețuire între persoane de același sex în Italia. Deci este posibil ca în anul 2021 ori 2022 CEDO să pronunțe o decizie similară privind România, să constrângă România să legifereze în legislația internă a României un drept sau o recunoaștere a uniunilor civile. În final am întrebat pe Gregor să ne explice dacă nu cumva este un conflict între autoritatea CEDO de a interpreta Convenția Europeană a Drepturilor Omului și a impune unei țări membre suverane cum să legisleze la nivel intern, ce legi să adopte, și dânsul era contrariat de aceste tendințe, însă ne explica că în ultimii 10, 15, 20 de ani, din nefericire la nivel global și mai ales la nivel european, există tendința, din nefericire, ca tribunalele internaționale să impună această obligație țărilor membre să adopte legislații interne care sunt compatibile cu interpretările pe care tribunalele internaționale le fac privind tratatele internaționale care au de a face cu drepturile omului. Mă reîntorc iarăși din nou la conversația mea cu Gregor în limba engleză și voi discuta alte 2-3 subiecte cu dânsul în seara aceasta. Gregor, thank you very much for allowing me 2 or 3 minutes to explain briefly the very fine points that you have made concerning abortion and same-sex unions and marriage as they've been explained in European jurisprudence by the European Court of Human Rights and the European Parliament. I'd like to go back to a comment that you have made. You have used a very interesting expression, and after you and I discuss this for the next 5 minutes or so, I'm going to go back and explain this very important term in Romanian to the public in Romania to make sure that Christians understand a concept which in my mind is a dangerous concept. It might not be in your opinion, but for somebody schooled formed in the United States, in American jurisprudence, it's a particularly disconcerting concept. You said that the European Court of Human I apologize. You said that the European Convention on Human Rights is being viewed as a living instrument. And I would like to focus on this terminology that we have used. We do have a conflict in the United States, and it can be seen in just about every major decision which comes down from the Supreme Court of the United States. There's always a fight between the so-called progressive wing of the Supreme Court and the more conservative wing of the Supreme Court of the United States. The so-called progressive wing, they believe that the Constitution of the United States, written more than 200 years ago, is a living instrument, like you said, very professionally. It's an instrument which we believe needs to be interpreted today by us in light of current contemporary realities. On the other side, on the other hand, you've got the so-called originalists or conservative judges who promote this notion of of originalism, meaning the Constitution does not change. If the Constitution is to be changed and its meaning, it's got to be done by the people by way of constitutional referenda and so on and so forth. So let's see if you can dwell on this subject for the next 2 or 3 minutes. My understanding is that in Europe, the European Convention of Human Rights is viewed as a living instrument. And so in this context, I would like for you to explain for the public in Romania, and not only in Romania, everyone who is going to listen to our interview, what exactly is an activist judge? Is there a link between this jurisprudential ideology, which is believing that a constitution is a living instrument, and an activist judge? And is that a problem in the European Court of Human Rights, in Europe in general, and whether or not this could be a threat to Christians and our understanding of Christian values?
Thank you very much. Yes, it is an important question. The declaration that the convention is a living instrument clearly has an effect to give an important power to the judges, because the judges may even change the content of the convention. So this is a huge change in the role of the court, in the role of the judges, and of course, it is a very progressist approach, because the purpose of such approach is to make the Court of Human Rights for Strasbourg a kind of European constitutional court, European Supreme Court, that could be the court competent to control all national systems under most aspects, and would not be limited anymore by the European Convention of Human Rights. Such approach is clearly motivated by a progressist vision, a dream of legal unification of the continent, and a supranational understanding or dream or vision of the European institutions. We may also say that such approach is not strictly necessary, because the states, if they want to create, to recognize new human rights, there is a way to do that. The way to do it is to adopt new conventions, or what is called additional protocols to existing conventions. And in fact, the European Court of Human Rights has already a number of such additional protocols, such as the one, for example, prohibiting death penalty. Death penalty was not prohibited in the Convention of Human Rights, and the states decided later on to agreed later on to prohibit it, and then they adopted a new additional convention. So there are two ways to update to human rights, to create, recognize new rights. One way is within the hands of the states, and respect the rules of international law. And the other way has been taken by the judges to have the initiative to do it according to their understanding of the priorities. And clearly, it gives facilities for the judges that are the most ideological to promote new rights and to use the system of protection of human rights as a tool to change the societies. And so what we can see is clearly that human rights are used for social engineering in a large extent. So this is clearly what we see. And it is based on the idea that the role of the European Court of Human Rights is not only to protect human rights, but also to develop human rights. So this is the two ways that are possible, I mean, that are used today. One is legitimate, the other one cause much problems and difficulties.
Yeah, the other one is questionable. Thank you very much for this very lucid presentation. If you'll give me a minute, I'd like to explain to the Romanian public in Romanian what you just explained to us in English. Dragilor, ceea ce spunea Gregor e foarte important și vreau să fiți cu mare atenție. Există pericol pentru democrație, pericol pentru valori în România și în toate țările care subscriu Convenției Europene a Drepturilor Omului, deoarece majoritatea judecătorilor din Curtea Europeană a Drepturilor Omului văd în Convenția Europeană a Drepturilor Omului un instrument viu. Îmi dau seama că folosesc anumiți termeni care sunt poate dincolo de așteptările sau înțelegerea dumneavoastră, dar această expresie instrument viu înseamnă că această convenție adoptată în 1949 este un document pe care niște judecători pe care nimeni, absolut nimeni nu-i alege, nu sunt aleși în mod democratic, stau acolo în Strasbourg și pot interpreta acel document care a fost adoptat acum 70 de ani într-o manieră care este în întregime contradictorie înțelesului original al documentului când a fost adoptat acum 70 de ani. Deci e un pericol. Pe de altă parte, Gregor ne spunea foarte lucid și foarte interesant, există un remediu pentru situația aceasta cu care eu sunt de acord și anume această convenție poate fi revizuită de comun acord de țările care deja au subscris la Convenția Europeană a Drepturilor Omului prin așa numitele protocoale adiționale care sunt negociate de țările membre, de statele membre și dacă țările sunt de acord să aducă o noțiune nouă, o ceva noutate sau ceva nou în această Convenție a Drepturilor Omului Europeană, pot să o facă. Dar, cum spunea și dânsul, din nefericire, la ora actuală, foarte mulți judecători din Curtea Europeană a Drepturilor Omului folosesc această convenție pentru scopuri de social engineering, adică cu un scop politic, scopul de a crea, de a inventa noi drepturi care să influențeze societatea și, în opinia mea, chiar să fie o amenințare la adresa democrației și a statului de drept. Going back to our conversation, Gregor, I know time is sort of running away from us. There are many more subjects I would like to talk with you about, but in light of the conversation that you and I have had concerning the European Court of Human Rights being a, quote, living instrument, I want to bring in our discussion a case. I do not know what the status of this case is right now before the European Court of Human Rights, but about a year ago, you have really drawn my attention to a fascinating case coming out of Slovakia, where, from what I understand, an inmate convicted of child molestation, I might be wrong about it, or some sort of a sexual crime, sued Slovakia in the European Court of Human Rights, demanding a right, the recognition of a right to access to pornography, hardcore pornography or whatever. And it really took me aback when I read that article that you have written. I do not know any updates about that case, and so in my mind that clearly is an example where the European Court, if indeed it recognizes the right to pornography for inmates especially, it really would be an extreme case of somebody really interpreting the convention as indeed of human rights as a living instrument. So please take it from there. What are your impressions, please?
Yes, so there is this case is still pending before the European Court of Human Rights, and the question is whether or not the protection of private life includes a right to access to pornography, as well as the protection of freedom of expression. So this case will be decided in the coming months or year. We don't. It's quite difficult to see what will be the decision of the Court of Human Rights, because quite often the court has protected freedom of expression to a large extent, including obscenities. So we may say that the natural liberal approach of the court, or libertaire, as we say in French, approach of the court may tend to a kind of protection of the freedom to access to such materials. So we will see what will be the decision. Another case pending that you may be interested in, which is quite similar, has been introduced by a large number of sex workers, prostitutes, maybe 200 from France, and as well they sue France because of the prohibition of prostitution, and they pretend that such prohibition go against their individual freedom, and also go against their material financial rights, and that it would be a violation of human rights. So now also we have also such a new crazy case whereas prostitution would be or not protected by human rights. So we can really see that in fact there is no clear limits to what we call the principle of autonomy, to what we call private life. You may in fact pretend that any practice that you do or want to do is covered as a human right and protected as a human right within the in respect to the right to protection of private life. So there is no limit. We could also speak about the use of drugs, for example, that may also clearly be argued and presented as a human right. Dangerous practices, many things, are such presented. And this is, I would say, the main problem today. One of the main problems today of human rights, it is the fact that the protection of private life, that in 1950 was aimed at protecting our home, now is used to protect all our activities. And this is clearly a huge extension of the scope of this right. It is also in the name of the right to private life that people will ask for a right to euthanasia, or a right to abortion, or now a right to pornography, or now a right to prostitution. So it's clearly the demonstration that morals, the sense of morals and of common decency has been lost in a large extent. But also, it also shows that the system of protection of human rights has much difficulties in identifying the limits of individual freedoms and liberties. This is today what we are facing. What are the limits? Do we have any limits are there any limits to our behaviors? Are there any inner limits? Can the court find any limit to the principle of autonomy? The court has already said that the principle of autonomy protects the right to hurt yourself, or to hurt someone else if the person consents. The courts recognize that it protects the right to kill yourself. So why not the right to prostitute yourself? I mean, it is really a full no-limit understanding of freedom, because in fact we have renounced to any kind of anthropology. We don't really agree anymore, on what it means to be a human being, what it means to have a good life. So we say, okay, it belongs for anyone, to decide what it means to have a good life. So if someone wants to be a prostitute, to use pornography and then to kill himself, it's good for him. It is his life. It is his freedom. We will just protect his right to do that. We will not help him. I mean, we will just let him do and avoid, and condemn the state if the state wants to prevent him from doing that. So it is very ironic, but it is very sad because in fact we have lost the vision, the common vision of what it means to be a human being, what it means to be, to have a good, proper life.
Very interesting comments, Gregor. You certainly possess a lot of information, a lot of useful information, and I'm really learning from you as we go with this dialogue. Give me again a minute so I can go and switch to Romanian and explain to the public in 1 minute what you just told us. Dragilor, l-am întrebat pe Gregor să ne explice dacă există un drept la pornografie recunoscut de către Curtea Europeană a Drepturilor Omului, ori dacă Convenția Europeană a Drepturilor Omului recunoaște un drept la pornografie. Motivul pentru care am pus întrebarea aceasta este că cu aproximativ un an în urmă, un deținut din închisoare din Slovacia a dat în instanță Slovacia solicitând acces la pornografie. Deci el era în închisoare, dacă nu mă înșel, era în închisoare din cauza unor crime sexuale împotriva minorilor și solicita acces la pornografie în închisoare. Lucrul acesta a fost interzis și ca atare a dat în judecată Slovacia pentru a-i se recunoaște de către CEDO un drept la acces la pornografie. Ne spunea domnul Gregor că acest caz încă este pe rol, nu a fost decis. Ne spunea că în spatele acestui caz există noțiunea aceasta de drept la viața privată și dânsul menționa foarte inteligent și foarte apropo, foarte bine, relevant. În 1950, când Convenția Europeană a Drepturilor Omului a fost adoptată, noțiunea de dreptul la viață privată avea un anumit înțeles, iar în 2021 noțiunea de drept la viață privată are un înțeles probabil total diferit, cum spunea și dânsul, inclusiv dreptul de a determina pentru tine însuși să nu mai fii o ființă umană, să fii altceva decât o ființă umană. Deci sunt niște lucruri extrem de, nu doar interesante, dar extrem de periculoase pentru viitorul nostru, a societății, și rămâne să vedem cum acest caz și alte cazuri similare vor fi decise de către CEDO. Mai am o întrebare sau două pentru Gregor și după aceea ne apropiem de sfârșit. Gregor, I do have a whole bunch of more questions for you, but I think I'm only going to tackle one more. About a year ago, your organization, ECLJ, European Center for Law and Justice, has put out one of the most fascinating reports I have ever seen with respect to the European Court of Human Rights. And it's called The NGOs and the Judges of the ECHR between 2009 and 2019. Well, yes, great. So thank you very much. The persons that are helping us out with our conversation tonight do have this study. I'm grateful that they put it on the screen. So those of you who have not yet read this document, I wholeheartedly encourage you, I persuade you. I would like for those in the background to put back on the screen the title of the study. It's 25, 26 pages. Folks, I invite you, I persuade you, I beseech you to read this very important study. Gregor, it's been an eye-opener for me. And you have done a great job in putting together this study, one of the greatest studies that I have seen that ECLJ has put out. And I would like to ask you to explain to the Romanian public what are some of your main findings. If I'm not mistaken, I actually commented once or twice on my Facebook page about your study, and among others, I told the public that it seems that Mr. Soros, George Soros, indirectly through a whole bunch of open society foundations, which he has all over the world, including Europe, is apparently having some influence on the judicial thinking, on the decisions, directly, indirectly, of the judges on the European Court of Human Rights, which to me is a danger to democracy, to the rule of law. And so I'd like to ask you to tell us about this study and some of your findings.
Yes, okay. So the study looks to the activities and the profile of the judges of the European Court of Human Rights since 2009, during the last 10 years. What people have to know first is that it is not necessary to be a judge, to be a professional magistrate, to become a judge at the European Court of Human Rights. In fact, the states can propose 3 candidates for this function. Each state proposes 3 candidates, and the Parliamentary Assembly of the Council of Europe will pick up one of the 3 candidates to become a judge in Strasbourg within this court. And you know how much important is this court and how much power this court has on nation states and legislations. So what I have witnessed is an increasing role, presence of NGOs acting within the Court of Human Rights, introducing cases, advocating, and so on. And I have to say, we do the same here at the European Center for Law and Justice. We also bring cases before the court. So this is normal. But it starts to be problematic when such organizations like the European Center for Law and Justice, but also other organizations, send judges to the Court of Human Rights. And we have witnessed that there are 7 organizations active before the European Court of Human Rights, bringing cases to the court, supporting cases to the court. 7 organizations have sent some of their employees or collaborators to the Court of Strasbourg as judges. So this creates a problem because some lawyers, activists once become a judge before the same jurisdiction. So this is one first problem. 7 organizations and have sent 22 of their staff, we could say, before to the European Court of Human Rights as judges. Among those 7 organizations, one organization, the Open Society of Mr. Soros, have sent 12 people as judges to the Court of Human Rights, but also have financed the 6 other organizations. So in fact, there are 22 judges in the last 10 years out of 100 that are either former staff from the Open Society, either coming from organizations financed by the Open Society. So it is a lot. This is one problem. But there is also another problem, is that most of those judges, of course, have been faced with cases introduced by their former employer organization. And of course, it is a duty for judges, to do not rule on such cases. But we found at least 88 rulings in the past 10 years in which those judges have adjudicated applications introduced by their own former employer, their own former organization. And so this is a clear problem of numerous conflicts of interest. So those are the main findings of this report. It demonstrates the grip, the influence of some large foundations, especially the Open Society Foundation, but also a few others, on the system of protection of human rights. This influence of private actors on the public institutions is, of course, problematic. It is massive. I have only described one aspect of this influence because it was, in some extent, easy to find the numbers, the figures, and the evidence. But of course, the grip of those large foundations over the system is also present on many other aspects and within many other bodies of those international institutions. And what we can say, as we can say, that this report was eye-opening because it really showed one aspect of this important collusion between private interests and international institutions that are vulnerable because they are quite poor, often poor, whereas the large foundations are very rich. So we can see how the equation works. You have on the one side rich foundation with a lot of political ambition, and on the other side quite poor public institutions with a lot of political power. And so the two will meet and in large extent merge.
It certainly is a problem, and just between you and me, I have not formulated a solid view on this subject. But in listening to you and reading your report, Gregor, I ask myself occasionally whether or not the European Court of Human Rights is slowly but surely becoming, I dare say, a threat to democracy and to our human rights. They are, like you said, 7 organizations that you have studied and discussed in your report, open society organizations. Then you also mentioned Amnesty International and some others, and indeed you are very wealthy. They are very influential all over the world. And indeed, I think that the public needs to be concerned and worried when a lot of the former of the judges on the European Court of Human Rights also have been on the payroll or activists on behalf of these organizations all over the world. And I'm also concerned that, like you said, indirectly, the court is becoming a political court. The court is becoming ideologized. It's becoming what it should not be, like you also mentioned indirectly, a tool for the promotion of the interests, of the views, of the perspectives of wealthy international global NGOs, non-governmental institutions, and where the poor people, individuals like you and I and other people, cannot really make our voices heard in the European Parliament. What's your response to that? And let me know if I'm wrong about what I feel about what my intuition tells me.
No, it is true. If you are a private actor, if you are a private foundation, wealthy foundation, if you want to have an influence in politics, it is much more effective to go through the international organizations and moreover to go through the European Court of Human Rights and international jurisdictions rather than going through each member state. If you get a good judgment in Strasbourg, it has an effect on all 47 member states. So, I mean, it's much more easy to have an influence through the European Court of Human Rights than at each level and through the national states. So, we can say that the European Court of Human Rights, of course, is targeted by foundations, by pressure groups, by lobbies, in order to implement political visions, which is quite normal in large extent, but also the problem starts when those private groups get into the institution and become themselves the institution, when they become themselves judges. Because once we see that, of course, it is a huge tool of power for those foundations to have a hand to take control in large extent of those institutions. But the same, can be said regarding the World Health Organization. When you consider that the second source of finances, the second largest donor contributor to the budget of the World Health Organization is also a private foundation, the Gates Foundation, which gave, if I remember well, more than $450 million last year to the budget of the World Health Organization in 2019. So this phenomenon of financial and deep influence from those private actors, from those private supranational actors over the intergovernmental system is increasing and is increasingly problematic, because it is, of course, a direct threat for democracy, and even it is anti-democratic, because in substance, because it is fundamentally based, on a supranational, on a mondialist approach of politics, and the idea, that the world should be governed, by a minority, and so it's really a danger for democracy. If we want to keep the control of our existence, of our political existence, we need to clean those international organizations. We need to stop this grip, to give back the independence to those organizations. I think with this report that we have published, one of the first fruits could be seen last week when the Open Society of George Soros, for the first time, failed to get one of its employees elected at the European Court of Human Rights. This was concerning the vote on the judges for Belgium. Last week, one of the three candidates is an employee of George Soros, and it has been refused eventually. And this is a good solution, a good result, and it really serves the independence of the court at the end.
Yes, and I saw that in the news as well, and I do dare say that I think that the rejection of that judge likely was the result of your efforts and the well-publicized study which you put out. We are nearing the end. Just a couple of comments, because you certainly stimulate my thinking, and it's really a pleasure having this conversation with you. As you were discussing some of these topics, Gregor, what dawned on me is, with all of this external influence and the background of all of these judges, it must impact the selection of the cases that the European Court of Human Rights is going to accept to review, inevitably. I see problems with recusal. I see problems with conflict of interests. I see problems with peddling influence, in the European Court of Human Rights. When you have essentially, like you said, activists, people that maybe 10, 15, 20 years have done nothing else before becoming judges, instead of being on the bench in Paris or in Bucharest or in Ireland, they are somewhere out there in the world, flying to New York and Paris and having these conferences and peddling influence and a specific goal of one of these NGOs. And then probably some of them don't even have serious legal background training. They end up on the European Court of Human Rights, and they impose on us the vision which they've been promoted for money in New York and London and Paris and Rome and so on and so forth, 10, 15, 20 years. It cannot be right. It cannot be just. There's got to be a problem with it somewhere.
Yes, that's true. That's exactly what the situation. Regarding the selection of the case, people must know that about 95% of the applications brought by individuals before the European Court of Human Rights goes directly to the basket, is not accepted. So 95%, it means that there is a huge selection of cases. And if your application is rejected, you have no precise explanation why it is rejected. So the issue of the selection of the applications is very important, very central. And it is difficult from outside to assess how it works. There are a number of criteria, that's true, that apply. However, within those past 20 years, I have witnessed a number of times strange decisions to refuse the application of some cases that were very serious. For example, I remember we have been representing a group of 200 or 300 parents that have been sentenced by Spain because they refused to send their kids for some teachings that are against Christian morality. Those parents represented, in fact, 50,000 conscientious objectors, families in Spain. So it was a huge opposition of 50,000 people supported by the Catholic bishops of Spain. And so it arrived to the Court of Human Rights. So it was a big, important case, very political, very sensitive on the issue whether or not, there is a right for the parents to to keep their child out of some problematic teachings that were very anti-religious. And this application has not been considered. They just received, a short letter saying, we don't see anything in your case that is interesting. We don't think it is, it can be, proceed. And so it is rejected without any other explanation. So we have seen a large number of such problems for really serious applications. So sometimes I have to say I have doubt, on the real reasons why those applications have been rejected without judgment. But of course, there is no possibility, and I'm not the only one. I'm not the only one to have such doubts. But of course, we have to trust the court normally, and we have no ways to assess again this decision.
Yeah, I do remember very well the Spanish case that was rejected. That was 5, maybe 6 years ago. I did watch with interest the evolution of that case, and I was very disappointed seeing that the Spanish case was rejected, which brings to mind a similar, well, not a similar case, but a somewhat similar case which Romania brought back in 2016. Maybe you're not aware of this case, but it's the Bodnariu case. It's a family of Romanian Christians who lived in Norway. Their kids were kidnapped by the Norwegian Barnevernet, and the parents instituted proceedings against Norway in the European Court of Human Rights, claiming that their parental rights had been violated. The European Court rejected the case after sitting on the case for 4 years. They rejected the case, and I see that case, the Spanish case, somewhat similar to the Bodnariu Romanian case, in the sense that it implicates a lot of the same principles, specifically parental rights, which, by the way, are extremely, extremely important. And I'm not seeing too much case law in that regard coming down from the European Court of Human Rights. Gregory, if you'll give me about 2 minutes to do a brief summary in Romanian of our conversation for the last 10 minutes. And there are a couple of books which I would like to recommend to the public in Romania and outside of Romania, great books on the subjects that we discussed tonight. Dragilor, ultimul subiect care l-am discutat cu Gregor privea acest studiu pe care l-am comentat deja pe pagina mea de Facebook și vi-l recomand din nou. Este studiul NGO and the Judges of the European Court of Human Rights 2009-2019. Este un studiu extraordinar care a fost scris și publicat de organizația domnului Pupnic din Franța, care dovedește influența extraordinară și nocivă, în opinia mea și a dânsului, pe care organizațiile neguvernamentale, așa numite progresiste, ale domnului Soros, Amnesty International și altele le au asupra Curții Europene a Justiției, a Curții Europene a Drepturilor Omului. E un subiect extrem de delicat, un subiect extrem de serios. Dânsul ne spunea, de exemplu, că organizațiile domnului Soros, Open Society, au reușit să pună în Curtea Constituțională a Drepturilor Omului numai puțin de 12 judecători în perioada aceasta de timp. De asemenea, alte 6 organizații neguvernamentale mondiale, cum e Amnesty International, au plasat în Curtea Europeană a Drepturilor Omului 26 de judecători. Deci imaginați-vă conflictul de interese când în fața acestor judecători activiști apar cazuri care au de a face cu principiile morale, valorice, care ne sunt nouă dragi, apar în fața acestor organizații mondiale necreștine, progresiste în ghilimele, anticreștine, antivalori dacă vreți. Ne putem doar imagina modul în care aceste cazuri ar putea fi decise împotriva noastră. Mai am vreo 5 minute cu domnul Pupnic și ce vreau să facem în încheiere este să vă prezentăm 2-3 cărți pe care vi le recomandăm dumneavoastră în România, toate sunt în limba engleză, le recomandăm de fapt nu doar celor din România, ci de asemenea și celor din alte țări care sunt interesați în subiectele care le-am discutat eu cu Grigor în seara aceasta și care pot fi cumpărate și citite în limba engleză. Okay, Gregor, we are approaching the end. Again, I thank you very much for your patience and your endurance. It's been a marathon day for you because probably you have already worked for 10, 12 hours. I just started 3 hours ago in my office, and I still have about 9 hours to go before I turn the lights off. But in the end, I would like to briefly mention to the public 3 books that you and I have discussed before we went live about some of the topics that we discussed tonight. The first one is Fake Law. And I do not know if you have been able to either purchase or read anything about this law, but I do recommend it to anyone that's interested in the fascinating topic of human rights, because this book was published by a British barrister, an attorney specialized in criminal law and human rights in the UK, which shows some of the bizarre, it showcases some of the bizarre rulings and decisions of the European Court of Human Rights, including the European Court of Human Rights prohibiting the UK government from deporting members of ISIS, which have taken up arms against the United States and the Western world. And so according to a European Court of Human Rights case law, they cannot be stripped of their UK citizenship or be deported from the UK. A couple of comments, if you have, about this book. I do recommend it wholeheartedly. And maybe you can tell us a few things about the tension that that apparently there is between the UK courts and the European Court of Human Rights.
Sorry, sorry, could you please repeat? I did not hear you well.
Yeah, the book that I am showing right now is Fake Law.
Yes.
Published by a British barrister specializing in criminal law and in civil rights.
Yes.
And it does talk about the tension between some of the rulings of the European Court of Human Rights and UK courts with respect to the area of human rights. Can you tell us anything about this so-called conflict between the continental jurisprudence and the UK jurisprudence?
So yes, there is a conflict between, of course, the approach the UK and the EU, and the Council of Europe and European Court of Human Rights. The UK, as you know, has a very long and respectful tradition of protecting human rights with the habeas corpus, the Bill of Rights. So they are really the ones that, in large extent, started the protection of individual rights against the state. And they have a long tradition based as well on case law. and they have many reasons to be proud of this system and reluctant to submit to some decisions from the European Court of Human Rights that are taken by, as they call them, foreign judges. So there is a matter of independence of justice, but also we could say of proudness of the British to keep the control over the system. So this is this conflict sometimes have occurred with a high intensity in some cases. For example, the one concerning the right to vote for prisoners. However, this discussion today arrives in the context of the Brexit. And once the UK have left the EU, the question remains whether or not the UK will stay within the Council of Europe, because there are two different organizations. There are strong voices in London, in the UK, that advocate for leaving the Council of Europe and therefore leaving the ECHR, the European Court of Human Rights. And this book, and I see it received a large audience, a large important success, will advocate in favor of leaving the system. The main problem then will be maybe financial, because if the UK leaves the Council of Europe, leaves the European Court of Human Rights, then it will start a new financial crisis for the Council of Europe. It will really jeopardize its future, and also it will, in a large extent, open the gate for other states to leave the system. So this could really endanger deeply the future of the system if UK leaves the European Court of Human Rights. And once UK is gone, it would demonstrate that the system is not so strong, so solid, and maybe other states like Turkey, for example, or Russia, or Poland, or whatever, maybe not Poland, but Turkey or Russia will maybe consider doing the same, and this would be the end of this dream from the end of the Second World War to create, legal unity between the states of the continent of Europe. So this is really a threat for the system.
So really we are living in very interesting times concerning the European Court of Human Rights, the fate of the court, the fate even of the European Convention of Human Rights. The second book I would like to recommend to the public is written also by a British person, and the name of the book is The Conservative Human Rights Revolution, European Identity, Transnational Politics, and the Origins of the European Convention. I do recommend this book again to everyone who is interested in the origins of the European Court of Human Rights, the origins of the European Convention on Human Rights, and how the legal jurisprudence on the institution as such, the European Court of Human Rights, has evolved since 1950 all the way to today. And Gregor, yes, I did look at the index, and I was curious to see if your name is mentioned in the book, and unfortunately it's not there. And I'm saying that sort of tongue-in-cheek, trying to put a smile on my face. But you have certainly done a lot of good work in the area of human rights. You are really, in my mind, an athlete of Christ, one of Christ's athletes. And not only you, there are others as well out there, colleagues, dear colleagues in the Alliance Defending Freedom in Europe, in the United States, and other wonderful organizations. American Center for Law and Justice in Washington, D.C. have done a lot of good work. And the last book, which I would like to present to the public in Romania, and you and I have something in common about the author of the book, which I'm recommending to anyone to read. It's called Under Siege. And actually today I posted a brief book review of the book on my Facebook page. The author of the book is Austin Roos. Under Siege. No finer time to be a faithful Catholic. Austin is an outstanding man, a friend. I have known him for a long time, and I understand that he's a friend of yours as well. Gregor, I do not know if you have gotten to read the book or not.
Not yet.
Not yet, but
not yet. But I have to say that Austin Roos, he's doing a very important work and advocacy with the United Nations for about 30 years. So his work is very important. He's a great man, very courageous, fighting, with courage and strength. So it's an important man.
Excellent. Again, I encourage everyone to read this book. A couple of comments in Romanian, and then we will be done. Deci, recomandam ultima carte pentru cei din România. Este cartea aceasta care chiar acum a ieșit, a fost publicată, scrisă de Austin Roos. Am făcut o mică recenzie a cărții, cam de o pagină pe pagina mea de Facebook. Vă încurajez să citiți recenzia pe care am citit-o. Este o carte care pentru români chiar iese la timp. Fie că ești catolic, fie că ești ortodox, fie că ești neoprotestant, e irelevant. Faptul este că nu a fost niciodată în istorie o vreme mai frumoasă, mai potrivită să fii un creștin decât astăzi, pentru că în această lume întunecoasă noi strălucim asemenea unor stele pe cer și ne putem face contribuția la promovarea, alfabetizarea acestei generații fără Dumnezeu în valori. Putem fiecare dintre noi fi un misionar, un evanghelist, un misionar, cum spuneam, care să promoveze valorile în aceste vremuri dificile. Și cartea aceasta chiar o recomand, citiți niște recenzii online, mai ales în această perioadă a Sfintelor Paște. Și din nou, cum spuneam la început, încheiem aici discuția din seara aceasta. Vă spun tuturor Paște fericit, Hristos a înviat. Gregor, we are going to stop our very interesting conversation here. I would like to have you again on my Facebook page for another discussion. There are many other subjects and cases, fascinating cases out there that deal with freedom of conscience, freedom of religion. The pandemic, we haven't gotten to them yet, but they are important. And hopefully we can link up again and continue our conversation some other time. Thank you again. In Romania, it's Easter this weekend. So if you want to say anything to the Romanian people, also faithful about Easter, happy Easter, whatever, you have the last word.
No, of course. I wish you a happy Easter, and all my best wishes for this important moment. For the church, for our prayers, for our soul, and for our families. So my best wishes to everyone, and God bless you all, and God bless us all. Thank you.
Amen, I agree. May God bless all of us. Thank you very much. Mulțumim frumos, la revedere, noapte bună, Paște fericit.